Welcome back to Central Colorado Ballistics. My name is Wally. In 2008, the baseline changed. The Supreme Court had spoken, but Colorado had already built its own structure. Now the question was no longer, is there an individual right? The question became, how far does it extend? And who defines its limits? From 2008 to the present, Colorado would test incorporation, test preemption, test legislative authority. This is not a story of personalities. This is a story of structure under pressure. In 2008, the United States Supreme Court decided District of Columbia versus Heller. In 2010, McDonald versus City of Chicago applied that right to the states. Colorado's constitutional framework now existed within the federally enforceable individual right structure. But Colorado already had Article 2, Section 13, the state's own right to bear arms provision. The question became procedural. Would Colorado's reasonableness framework survive strict federal scrutiny? Litigation increased. Challenges expanded. But the structural balance held, not unchanged, but not erased. In 2013, Colorado enacted significant firearm legislation. Universal background checks were introduced for nearly all private transfers, including those conducted at gun shows. High-capacity magazines were restricted, limiting capacity to 15 rounds. Procedural adjustments refined how lawful transfer and ownership could occur. These measures reflected Colorado's continued evolution from municipal divergence to statewide legislative assertion. This was not municipal divergence. This was statewide legislative assertion. Litigation followed. The laws were challenged in courts, including federal review of Second Amendment implications. Courts evaluated the measures under both federal Second Amendment analysis and Colorado's constitutional provision. The framework did not collapse. It adapted. Colorado's 2003 Preemption statute had narrowed local authority. But tensions resurfaced. Municipalities explored regulatory authority within home rule boundaries. The question reemerged: state uniformity or local autonomy. In 2021, Colorado formally allowed local governments to adopt stricter firearm rules than state baseline law, creating a new balance between preemption and municipal authority. Courts, once again, became arbiters of structural boundaries, not of ideology, but of jurisdiction. In 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruen. The methodology changed. Means and scrutiny gave way to text and history analysis. Colorado's framework now faced a different constitutional lens. Subsequent legislation further refined the framework. In 2023, a 3-day waiting period was implemented. In 2025, a permit-to-purchase system for semi-automatic rifles was established, requiring training for buyers. These measures are currently facing federal court challenges, testing the boundaries of state and federal constitutional authority. Not reasonableness, not balancing test. Historical tradition. The Incorporation era had entered its next phase. From municipal ordinance to judicial balancing. From preemption to incorporation. From legislative restraint to legislative assertion. Colorado's arc is complete. Not because the debate has ended, but because the structure has been revealed. Every era tested a different boundary, and every boundary clarified the next question. Now, we rewind. Not west, but east. Before Colorado. Before expansion to 1776. Virginia, where the language that shaped the Second Amendment first took form. In the next series, we'll go into Virginia. See you in the beginning. Freedom secured, rights defended.